What about late fees with everything that's going on? I mean, is that something where you almost would tell your clients, look, we're going to be happy if we can just get the rent. Let's not start worrying about late fees. Or are late fees a viable thing that you can collect even given everything that's going on?
Uh, you have to look at your local moratorium. The city of Los Angeles specifically prohibits them. And, one thing that has also been confusing to many landlords is, okay, my local moratorium says X, Y, Z. Okay, so when I do the analysis, what I ask myself is the tenant even entitled to the protection of the local moratorium? So I look in the moratorium to see, was the tenant required to provide me any sort of notice each month that they weren't going to pay? If that's in there, it says within 7 days, for example, the tenant must provide the landlord, within 7 days of the rent becoming due, the tenant must provide the landlord notice or written notice that they're unable to pay the rent, et cetera, et cetera. If it has affirmative obligations that the tenant is supposed to comply with to receive the protections of the moratorium and the tenant didn't comply, my argument is that the tenant's not entitled to those protections at that point. Now, LA is interesting because not only does it not have affirmative obligations that the tenant is supposed to comply with, but it specifically prohibits late fees and interest. So if I were a landlord in LA, I'm not going to say forget them right now. You may be able to bring them at a later time in a small claims action or something, but I certainly wouldn't go after them right now. You have to read your moratorium on that.
Yeah, I mean, just personally, I mean, if you know a tenant's gaming the system, then maybe you're more inclined to go down that road. But if my wife and I, we've had a tenant or two who they've been paying, but paying late, and it's because COVID has put them back. Ever since March and April, their income had went down a little bit, and now they're playing catch up. We're choosing to waive those fees because they've always been good tenants, and so there's no need now for me to hinder that relationship.
I agree with you 100%. I said this at your educational webinar, and I'll say it again. Right now, unfortunately, the government on multiple levels has seen the need to step in and really shield the tenant from virtually every responsibility they have under the lease. I would tread cautiously if I were a landlord with a lot of things in my mind. I would tread cautiously because the government has stepped in and protected them. And that's kind of the theme of this COVID situation. I would tread cautiously because anything we do as an industry is going to reflect on us as an industry, as I said at the educational webinar. And I would tread cautiously because we want to demonstrate a level of compassion. Yes, there are tenants out there gaming the system. And if you can verify that and prove it, then there are remedies for that. There will be remedies for that as well down the road. But for right now, unless you've got verifiable evidence that they're committing fraud, then be patient. Try to unpack the laws. Certainly enforce your rights, but don't. I'm a fairly aggressive attorney, but even I draw lines where I say, okay, I'm not stepping beyond that line, and I would caution your clients to do the same thing. Assert your rights, use all the laws to your advantage, but be compassionate and don't step over those lines. And when in doubt, call an attorney and ask them to unpack something for you so that they can give you some guidance.
Going back to LA City, what about pass-throughs? Like I believe they call them SCEP fees.
SCEP fees.
SCEP fees.
Yeah.
In LA City, you're not allowed rent increases and these type of things right now. But what about pass-throughs? What happens with pass-throughs?
So LA City had a really interesting way of phrasing that. They, as part of their moratorium, they said no new pass-throughs. And it's a very vague word, new. What does that mean? I don't know. And we're not going to know until, we start working through this and we start getting some determinations. Is a new pass-through, there's several things that fall under pass-throughs. You can do capital improvements to your property and then go to the city of Los Angeles and fill out some paperwork, have a hearing. They will permit you to pass through some of the costs of those capital improvements to your tenants. So is that what it's referring to? Is that a new pass-through? Is SCEP fee a new pass-through? Because SCEP fees have been here all along. Those aren't new. Well, anything that they've already paid may not be new. What about SCEP fees for the year 2021? Are those new pass-throughs? I don't know the answer to that. It's that one word, new, that is really throwing some confusion into the situation. So I wish I could give you guys a black and white answer on that. I'll tell you what, because of the confusion, if it were me, I would certainly put my SCEP fees through as normal. And if the tenant decides to fight me on it, and I get a letter from the city saying, hey, these were covered under the moratorium, they're not permitted, then maybe I temporarily defer that SCEP fee until a later date. But I would feel comfortable, because of the confusion created with that word, I would feel comfortable saying a SCEP fee is not a new pass-through. It's an existing pass-through, and I intend to seek it. Because let's face it, right now, I've got to get every penny on a rent control building that I can. And unless the city comes back and tells me specifically, no, that SCEP fee for that month is not permitted, I'm going to seek it.
So I guess we can safely say that being a landlord is not getting any easier, given our conversation the last minutes here.
It's currently incredibly convoluted is the best way to say it. I think if we ever get back to normal, and I keep seeing articles written by people saying we're never going back to normal, and you know, that may be true, I don't know. But if we ever get back to normal, the greatest hope we can hope for is statewide rent control is not going away. The greatest hope we could hope for is that we come under one unified law so everybody knows, okay, this is the law. If we're going to get there, I don't see it happening anytime soon, but certainly for the next, at least through next June, I would say, when summertime gets here and the vaccine has worked its way through society and COVID seems to be on the downturn or completely gone in quotes, as you can imagine. Yeah, it's incredibly complicated to do the analysis on every property. Chris, before we go though, I do want to ask a question of myself that you didn't ask me, but I'm getting it all the time. I keep getting asked, look, when I serve a notice and the tenant doesn't return the declaration of COVID in the 15-day period, you know, what can I do? Can I file an eviction? And the short answer is yes, you can. AB 3088 has built in there that if the tenant does not return the declaration for either period, the protected period or that transition period, then the landlord can immediately file an eviction. And I have a lot of landlords who have maybe a false sense of hope and a false sense of security under that. Again, going back to depending on what county you're in, what house you're in, what courtroom you're in, a lot of this is going to unfold at judge's discretion. But I do want to make your members aware of two, I'll call them get out of jail cards that exist for the tenant's benefit in AB 3088. So the first one is whether you serve a notice for the protected period or the transition period, where the tenant does not return that 15-day declaration, or that declaration within the 15 days rather, you can go ahead and file that eviction. However, once the tenant is served with a copy of the summons and complaint, under normal circumstances, they have to file an answer or some sort of response of pleading within somewhere between 5 days, and the code says 10, but some clerks actually give them 15 for various reasons. So somewhere between 5 days and 15 days, the tenant is required to file some sort of an answer or response. If in that period they file that declaration, so they didn't return it to you like they're supposed to, you file your eviction. Now within that 15-day period or 5-day period to file their answer, they file that declaration with the court. The court will actually have a hearing. And if the court determines that their failure to file that declaration was due to mistake, inadvertence, surprise, or what is commonly called excusable neglect, the court will dismiss your case. So that's the first get out of jail card. And that was actually, we just had one of those motions up in Pasadena. Thankfully, the court ruled in our favor and said, no, we're not going to grant you that. And they're allowing us to move forward. I was actually surprised when I found out which commissioner or judge it was. I wasn't too surprised. He's always been very fair. But in general, that's the first get out of jail card free for a tenant who fails to comply. Additionally, where your tenant in a situation where let's say your tenant fails to file that declaration, or they failed to pay the 25% by January 1st for the rent that came due in the transition period, and you go ahead on February 1st and you file that unlawful detainer, there's another get out of jail card for you for the tenant. The court can actually issue an order requiring the tenant to pay that 25% within 5 days. And if the tenant does it, your eviction will again be dismissed. So there are these built-in get out of jail free cards for the tenants that have to be weighed out before you file an eviction, because the tenant didn't file their declaration or they didn't pay that 25% by January 31st. So any landlord that's considering filing the eviction, before they do that, they should pick up the phone and talk to an attorney and walk through the facts of the situation and really know what are the risks they're facing before they go ahead and spend that money on an eviction, filing the eviction and all the court costs and filing fees and process server fees, only to have that eviction, dismissed, and them sitting there with their hands up saying, okay, now I have to either file it again or go through the small claims court, provision in AB 3088.
Well, Mike, you've been more than gracious with your time. I know that the clarity that you've brought to some of these outstanding questions has really helped the landlords, the viewers. I imagine there's still many more questions out there, and I would encourage our viewers to reach out to Mike Brennan. So, Mike, where can they reach you? What's the best way to interact with you if they look to seek your services?
Well, I'm going to give you a couple different ways, because as you said at the beginning, if you knew how many phone calls a day I and my other associates and my staff members were getting with questions, it would kind of blow your mind. So I'll give you two methods. The first method is just call me. You can use area code 626-294-0500, 626-294-0500. I'm trying my best to return every call every day. It doesn't always happen, so I apologize. If you get to a point where either I haven't called you back and it's getting to be an important question, I'm going to give you an email, which several people have started using, and it actually gets you a response relatively quickly. It is covid.info@mbrennanlaw.com. So I'll spell that COVID.info at M, like Michael, Brennan, BRENNAN, law, LAW.com. One of those two ways, I should be able to get back to you within maybe 48 hours at the latest. And I'm happy to answer anybody's questions, more so as a preventative measure to keep people out of the hot water right now.
I thank you, Mike. As our viewers know, we're very selective who we allow to come on this show. It's because we stand behind their services. And there's, of course, a lot of different eviction firms out there. But Mike is just a solid guy, stands behind a solid business. And so we're definitely happy to have him on the show today. So thank you again, Mike. And we wish you and your family all the best.
Thank you, Chris. I wish the same for you guys. Thank you.
I hope you found today's episode helpful. I hope the information shared really does help you in the day-to-day management of your properties. Please give our video a like, share your comments below. If you have any questions, please share those as well. We're trying to get this information into the hands of as many landlords and investors as we can. And by you sharing and subscribing, that ensures our content gets out there. In these times, I would just ask you to be proactive. Of course, there's a lot that comes to property management already without all the new restrictions. So stay proactive, stay diligent. We wish you the best here at the Apartment Dealer. On the growth of your financial legacy in your buildings. And should you have any questions with respect to the market, where are rental rates trending, where are values trending, what's the reality of what's taking place on the ground, please feel free to reach out to us. Chris German from the Apartment Dealer, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.